Compelled pronouns, biological reality, and the limits of law. 1. Introduction. The nature of language and law. Language is a shared convention, not state mandate. Why compulsion in speech is a uniquely dangerous overreach. Preview statistics on sex variation, law's demand for clarity, philosophy of liberty. 2. Grounding in reality, biological sex, and its rare exceptions. Data on true hermaphroditism, 0.001%, broader intersex, 0.018 to 1.7%, transgender identification, 1%. Distinction between biological reality, intersex, and identity claims, transgender. Public ignorance of these figures. Most people have no framework to understand them. 3. Law of vagueness, and the collapse of compelled speech. Doctrine of void for vagueness. Laws must be clear, predictable, and universally applicable. Why compelled pronoun laws fail. They hinge on subjective declarations. Comparison to Papachristou v. City of Jacksonville. Striking down vague loitering laws. 4. Constitutional precedents against compelled speech. West Virginia v. Barnett, 1943. No official can prescribe what shall be orthodox in politics or religion. Woolley v. Maynard, 1977. Government cannot force individuals to display state ideology. Compelled pronouns as ideological orthodoxy, by another name. 5. Philosophical foundations of free speech and truth. Mill, on liberty. Coercion of opinion stifles truth-seeking. Arendt, coercion destroys authenticity, producing compliance without conviction. Wittgenstein, language has meaning only through shared use, not imposed definitions. 6. Public and private realms, respect without coercion. In public, respect is voluntary, not enforceable. In private, individuals may construct linguistic communities of their choosing. Respect given freely retains dignity. Respect under law becomes parity. 7. The scarcity of informed voices. From the transcript, fewer people are informed about intersex than intersex people exist. Willingness to speak is rarer still, 0.1%. Expecting universal fluency in contested categories is unreasonable and unjust. 8. Case study, #Charlie Kirk, and the public discourse. Illustration of how prominent voices speak loudly without nuance. Shows the danger of letting ideology replace expertise in shaping law. Reinforces that most of the public debate ignores empirical realities. 9. Conclusion, freedom, truth, and the limits of law. Male and female remain the human norm. Rare exceptions exist but do not justify coercing the majority's language. Law should acknowledge truth, not legislate ideology. Compelled pronoun statutes are void philosophically, linguistically, constitutionally. Compelled pronouns, biological reality, and the limits of law. Introduction. The nature of language and law. Language is not created by governments, it is born of use, of shared life, of the natural rhythm of human recognition. Men call men men, women call women women. These categories need no state machinery to sustain them. They are self-evident, intelligible, and universally accessible. No legislature wrote the grammar of human recognition. It arose long before governments, and will endure long after them. When law intrudes into language, especially into the realm of compelled pronouns, it abandons neutrality. It moves from the role of arbiter to that of preacher, from enforcing order to prescribing belief. Such a move is not only philosophically untenable, but legally indefensible. Compelled pronoun statutes collapse under the doctrine of void for vagueness, under the constitutional prohibition against compelled speech, and under the weight of ordinary human experience. The discussion must be grounded not in ideological assertion, but in empirical fact. For the reality of biological sex, the rarity of exceptions, and the limits of public understanding reveal why coerced linguistic compliance is absurd. Biological reality, and its rare exceptions. The human population overwhelmingly conforms to the binary of male and female. This is not dogma, it is biology. Yet there are rare exceptions that deserve honest acknowledgement, without being weaponized to destabilize universal categories. True hermaphroditism, ovidesticular disorder of sex development, OTDSD, occurs in roughly 0.001% of births, about 1 in 100,000. This condition, in which both ovarian and testicular tissue are present, is vanishingly rare. Broader intersex conditions, defined variously, range from 0.018% of births, clinically ambiguous genitalia requiring intervention, to 1.7%, including non-typical chromosomal or gonadal traits, such as Klinefelter or Turner syndromes. Transgender identification, by contrast, is not rooted in chromosomal or gonadal variation, but in self-declared identity. As of 2025, approximately 1% of the U.S. population aged 13 and older, around 2.8 million people, identifies as transgender, with higher rates among youth, 3.3% of those 13 to 17. The contrast is stark: rare biological conditions affecting a tiny fraction of humanity, versus identity claims that encompass millions, largely independent of biological variance, public awareness, and the scarcity of expertise. Empirical research demonstrates that most people are not even minimally informed about intersex realities, let alone prepared to speak on them. A 2016 survey of U.S. college students found only 30.8% knew what intersex meant, while another 36.9% had merely heard the term. Even after definition, only 60.2% could demonstrate clear comprehension, and this among a population more educated than average. A 2022 UK-US survey of 271 participants revealed that intersex was conflated with non-binary identity, hermaphrodite was associated with plants or myths, and DSD was viewed through a purely medical lens, evidence of fragmented, superficial understanding. The result is paradoxical. The population qualified to speak on these issues with depth is rarer than the conditions themselves. Most intersex individuals have endured secrecy, stigma, or medical erasure. Many are not equipped or willing to discuss their condition in public. Specialists in disorders of sex development number only in the low thousands worldwide. The subset of individuals who are 1. Informed, 2. Respectful of binary categories, while acknowledging rare exceptions, and 3. Willing to speak publicly is vanishingly small, likely less than 0.1% of the population. Thus, the demand that the average citizen master this contested and obscure terrain, under threat of sanction, is absurd. It is to compel participation in an ideological exercise in which neither competence nor consensus exists. Law of vagueness, and the collapse of compelled pronouns. The doctrine of void for vagueness holds that laws must be clear enough for the average citizen to understand what conduct is required or prohibited. Vague laws are invalid because they delegate arbitrary power to enforcers, punish the uninformed, and fail to give citizens fair notice. Compelled pronoun statutes fail under this doctrine. They rest not on universally intelligible categories, but on self-declared, subjective identity claims that may shift without notice. No ordinary citizen can be expected to anticipate or memorize the private pronoun preferences of strangers encountered in public life. The law thus becomes a snare, punishing the well-intentioned and empowering the malicious. This is the same void for vagueness as in marijuana legalization of cannabis. The Supreme Court has consistently struck down laws for vagueness when they hinged on indeterminate standards, such as loitering statutes in Papachristou v. City of Jacksonville, 1972. If loitering laws were too vague to enforce, compelled pronoun laws are vaguer still. They criminalize the failure to affirm private self-conceptions that lack objective criteria. Constitutional precedents against compelled speech. The First Amendment prohibits not only the suppression of speech, but its compulsion. In West Virginia State Board of Education v. Barnett, 1943, the court declared that no official may prescribe what is orthodox in politics, nationalism, or religion, nor force citizens to confess by word or act their faith therein. Compelled pronouns function precisely as prescribed orthodoxy in matters of identity. In Woolley v. Maynard, 1977, the court struck down New Hampshire's requirement that citizens display the state motto "Live Free or Die" on license plates. Forcing pronoun declarations is the linguistic analog of forcing an ideological motto, an attempt to make citizens mouth the creed of the state. The court's reasoning is timeless. The right to refrain from speaking is as protected as the right to speak. Compelled pronouns violate this bedrock principle. Philosophical foundations of speech, truth, and freedom. The legal prohibitions against compelled speech echo deeper philosophical truths. John Stuart Mill, in On Liberty, warned that coercion of opinion stifles truth-seeking. If opinion is false, refutation will expose it. If true, compulsion robs humanity of the opportunity to grasp it freely. Compelled pronouns replace dialogue with decree. Hannah Arendt observed that coercion destroys authenticity. A coerced confession is not belief, but performance, hollow at its core. Compelled pronouns may create conformity in words, but not in hearts. Ludwig Wittgenstein emphasized that language gains meaning through shared use, not imposed definition. Pronouns have meaning because they are embedded in natural grammar. To legislate them is to detach language from its living root, replacing shared practice with artificial fiat. Together, these insights converge. Speech divorced from freedom ceases to be speech. It becomes theater, propaganda, coercion. Public and private realms. Respect without coercion. In public, the ethic is simple: act with maturity and respect. But respect cannot be legislated. The dignity of voluntary recognition is destroyed the moment it is compelled. In private, individuals may form linguistic communities according to their choosing. They may request, negotiate, and establish preferred modes of address. Freedom of association protects such arrangements, but to elevate private linguistic choices into universal laws to invert the order of liberty. The few command the many, the subjective overrides the objective. Respect given freely is genuine, respect commanded by law is parity, the scarcity of informed voices, and the perils of public discourse. As the transcript data shows, those who are both informed and willing to speak publicly about intersex realities are exceedingly rare. Yet public discourse is dominated by those with the least nuance, most ideology, and largest platforms. The late Charlie Kirk, for example, was an outspoken critic of transgender ideology. His rhetoric framed gender as strictly binary, dismissed transgender identity as a social contagion, and ignored intersex realities entirely. His voice was loud but not deep. His case illustrates the danger. Public discourse is filled with voices either ignorant of nuance or hostile to it. Meanwhile, those with expertise remain silent, unwilling, or unheard. This asymmetry ensures that laws shaped by discourse are not rooted in truth, but in noise. To enshrine compelled pronouns into law on the basis of such discourse is to legislate ideology without knowledge, conclusion, freedom, truth, and the limits of law. The overwhelming reality of human existence is binary, male and female. Rare exceptions exist, and they deserve honesty, compassion, and respect. But their rarity cannot justify the coercion of the majority into speech that affirms contested identities. Compelled pronoun laws are void on every front. Philosophically, they violate the nature of language, which emerges from use, not decree. Legally, they are void for vagueness and prohibited as compelled speech. Empirically, they demand fluency in matters of which almost no one is informed. Socially, they invert the logic of respect, making it a product of law rather than conscience. To legislate pronouns is to legislate belief. It is to declare that the state, not reality, decides what words mean. Such laws are not only unenforceable, but unjust. The path of reason is clear. Recognize the truth of male and female, acknowledge with honesty the rare biological exceptions, and protect the freedom of all citizens to speak or refrain from speech, according to conscience. Anything more is not inclusion but coercion, not law but ideology, not freedom but open tyranny in linguistic form.